Newly unsealed documents just shattered what remained of Trump's denials. Over 370 pages of previously sealed court filings were released by a federal judge in Manhattan, and they paint an absolutely damning picture of relationships and communications that Trump has spent years trying to bury. These aren't rumors or conspiracy theories. These are sworn depositions, flight logs with verified signatures, and witness statements that directly contradict every public claim Trump has made about his relationship with Jeffrey Epstein. When federal prosecutors include specific details about private dinners, phone calls logged at 2 in the morning, and arrangements made through intermediaries, you know the wall of denial just collapsed. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what set off this extraordinary release? A federal district court judge ruled on January 28th that public interest in transparency outweighed privacy concerns. The judge specifically cited the need for accountability when powerful figures may have been involved in or aware of criminal activity. This isn't just another scandal that will fade by next week. Members of Congress are already calling for immediate investigations from both parties. And believe me, when sitting lawmakers start demanding answers within hours of a document release, you know something genuinely explosive just detonated. Here's the full picture of what's been unfolding. Tensions around Trump's Epstein connections have simmered for years, fueled by Mar-a-Lago photographs and Trump's own 2002 statement calling Epstein a terrific guy who likes beautiful women on the younger side. But everything escalated on January 28th, when U.S. District Judge Loretta Preska ordered the unsealing of documents sealed since 2016 as part of a defamation case. The newly released materials include deposition transcripts from Mar-a-Lago employees, phone records from Epstein's Palm Beach residence, and calendar entries recovered from his Manhattan townhouse. According to court filings, one witness identified as Jane Doe, 147, testified to 22 separate occasions between 2001 and 2003 when she observed Trump and Epstein meeting privately. Her testimony included details only someone present could know: their preferred table in the dining room, Trump personally greeting Epstein at the entrance, conversations continuing for 90 minutes or more. Smash that like button if this is making sense so far. Here's where it really gets serious. When legal experts reviewed these depositions, they recognized this crossed from rumor into documented pattern. Sworn depositions carry federal criminal consequences if proven false. On January 29th, a bipartisan group of 19 House Oversight members held an emergency briefing. A Republican ranking member stated the documented contact was far more extensive than Trump acknowledged. A Democratic chair described the records as deeply concerning. By January 30th, they had sent a formal letter to Attorney General Merrick Garland using unusually direct language, referencing Trump by name in 7 paragraphs. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely explosive. The documents include phone records showing 73 separate calls between Trump Tower and Epstein's private line between March 2002 and November 2004. The records indicate 14 of those calls occurred between 11 p.m. and 3 a.m. One call on July 8, 2003 lasted 48 minutes. Another on September 23, 2003 lasted an hour and 7 minutes. These weren't brief check-ins. They were sustained conversations during hours when most business calls don't occur. What makes this significant is testimony from Epstein's former pilot, David Rogers, whose deposition was unsealed. Rogers testified under oath that Trump flew on Epstein's aircraft on at least 7 occasions between 1997 and 2005, contradicting Trump's public claim that he hitched one ride. The pilot's flight logs include passenger manifests with signatures that handwriting experts confirmed matched Trump's signature. The logs show flights from Palm Beach to New York on March 14, 2000. from Teterboro to Palm Beach on August 6, 2001, and 4 additional flights in 2003 and 2004. This sent shockwaves through legal circles. When federal court documents directly contradict years of public denials with documentary evidence, the claims that these were barely acquaintances collapse. This isn't the first time Trump has faced scrutiny over Epstein connections. Think back to 2016, when a lawsuit was filed alleging assault at an Epstein property. The case was voluntarily withdrawn before trial. Then there was 2019, when Epstein was arrested on federal trafficking charges and died in his Manhattan jail cell. Trump claimed he had a falling out with Epstein and hadn't spoken to him in 15 years. Many media outlets accepted that narrative at face value. The key difference then was the lack of documentary evidence to contradict Trump's version. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And let's not forget the 2020 Maxwell trial, where Ghislaine Maxwell was convicted on federal charges. Trump's name was mentioned briefly, but no direct allegations were substantiated. Now, however, it's different. We're dealing with phone company records, flight logs with passenger manifests, employment records from Mar-a-Lago, and sworn depositions from multiple witnesses whose accounts align on key facts. The pattern is clear. When documentary evidence contradicts years of denials, even the most loyal defenders face a reckoning with facts. So what makes this release so devastating? According to legal experts and former federal prosecutors who reviewed the materials, the documents establish a pattern of sustained contact that directly contradicts Trump's public position that he barely knew Epstein. Joyce Vance, former U.S. Attorney for the Northern District of Alabama and current MSNBC legal analyst, told reporters, "The volume and specificity makes this qualitatively different." She explained that when you have phone records, flight logs, and witness depositions all corroborating the same timeline, it becomes nearly impossible to dismiss as coincidence. Here's the kicker. The documents reportedly include a deposition from a former Epstein scheduler who testified that Trump's office would call to arrange meetings and that Trump's assistant would sometimes request specific dates when certain other guests would not be present. The scheduler testified these arrangements were coordinated with attention to who else would be present. This wasn't random social overlap. These were planned, coordinated meetings. Don't go anywhere. The most explosive part is coming next. And here's what should alarm everyone. This isn't just about one relationship or one set of documents. If a presidential candidate and later sitting president maintained extensive contact with a convicted sex offender during the period when that offender's criminal enterprise was operating, and if that contact was systematically denied for years, the implications for what else might have been concealed become staggering. This puts Trump and his legal team in an extraordinarily difficult position. On one side, they face mounting pressure from the documentary record. On the other side, they're forced to explain why the denials were so categorical if the truth was this different. They now have to reconcile barely knowing someone with 73 documented phone calls and 7 documented flights. And here's the tricky part. Legal analysts immediately recognized there's no credible middle ground. Either the records are accurate, in which case the denials were knowing falsehoods, or dozens of documents from independent sources are all somehow fabricated, which would require a conspiracy theory of breathtaking scope. Legal and political experts are calling this a credibility crisis with potential criminal implications. Andrew Weissman, former FBI general counsel and federal prosecutor who led the Enron investigation, told CNN that while the documents don't prove criminal activity by Trump, they establish his public statements about the relationship were materially false. He noted that false statements about relationships with individuals under federal investigation can constitute obstruction if they were made to mislead investigators. Rinaldo Mariotti, former federal prosecutor with the U.S. Attorney's Office for the Northern District of Illinois, added, "These revelations create enormous legal exposure." He explained that if Trump made false statements in any legal proceeding about his relationship with Epstein, those false statements could form the basis for criminal charges. Federal law prohibits making false statements to investigators, even if you're not under oath. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even Alan Dershowitz, who has frequently defended Trump's legal positions, acknowledged in an interview that the documentary evidence appears substantial. He stated that while proximity to Epstein doesn't prove wrongdoing, the extent of contact is surprising and will likely prompt further investigation. So, let's break down what this actually means. First, the immediate political impact is significant. We're in the middle of a presidential election cycle, and every Trump appearance will face questions about these documents. Before this release, the Epstein issue was considered old news. Now, documented evidence that contradicts years of denials has revived the story with far more credibility. Early polling conducted by Morning Consult showed Trump's favorability dropped 4 percentage points among independent voters, with 67% saying they were concerned. That's statistically significant movement in a short time frame. Second, this creates massive legal complications. These documents will almost certainly prompt new subpoenas and investigations. Congressional committees have requested briefings. State attorneys general in New York and Florida may face pressure to open inquiries. The Justice Department will face questions about whether it adequately investigated Trump's connections when Epstein was prosecuted in 2019. Finally, the third major implication involves the Republican Party itself. GOP officials face an impossible choice. Do they stand by Trump and explain away 73 phone calls and 7 flights as irrelevant, or do they distance themselves, risking the wrath of Trump's base? Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate political and legal fallout, this is really about truth and accountability in American public life. The president's credibility on matters of personal conduct goes to the heart of whether our political system can function when basic facts are in dispute. When a president can maintain for years that a relationship was minimal and documentary evidence then shows 73 phone calls over 2 years, 7 documented flights, and 22 witnessed meetings, we've moved beyond political spin into something more troubling. If documentary evidence this clear can be dismissed, what basis do we have for holding anyone accountable? This scenario is causing panic within Trump's inner circle. Multiple sources told Politico that senior advisors held emergency conference calls on January 29th and 30th to determine a response strategy. Some argued for attacking the judge who ordered the unsealing. Others insisted that approach would backfire. The campaign is fractured on messaging. Meanwhile, Trump's core supporters have responded with fury on social media. But polling data suggests even some within Trump's base are troubled by the specificity of the evidence. A focus group conducted by Republican pollster Frank Luntz found that 34% of Trump voters expressed concern about the revelations. Things escalated further when Trump responded on Truth Social with a series of posts on January 30th. He called the document release a disgraceful witch hunt orchestrated by radical left prosecutors trying to interfere with the election. He claimed he barely knew Jeffrey Epstein, that everyone in Palm Beach society knew everyone else, and that he had nothing to do with Epstein's terrible crimes. The posts attacked Judge Preska personally, calling her an activist judge with a vendetta. Stay with me. What comes next will completely change how you view the situation. Here's what makes this response problematic from a legal and political standpoint. Trump's own statement directly contradicts the documentary record that has now been made public. Claiming to barely know someone after phone records show 73 calls and flight logs show 7 trips creates an obvious credibility problem. When your first instinct is to attack the judge and claim political persecution rather than addressing the substance of 370 pages of documentary evidence, you signal the evidence itself can't be effectively challenged. Legal experts immediately noted this defensive posture. Barbara McQuaid, former U.S. Attorney for the Eastern District of Michigan, tweeted that attacking the messenger rather than the message is a classic sign that the underlying facts are damaging. She pointed out that if the phone records were inaccurate, Trump's statement would have said so. This goes far beyond one set of unsealed court files. It's about whether public figures can maintain demonstrably false narratives for years and face no consequences when documentary evidence proves the falsehood. If a president can deny a relationship while phone companies have 73 calls logged, pilots have 7 flights documented, and witnesses have testified under oath to dozens of meetings, and if that president faces no political or legal accountability, we've established that truth is negotiable and evidence is irrelevant. Once that precedent is set, there's no floor. If this blows your mind, hit that like button right now. Here's the situation we're actually facing. A federal judge just unsealed 370 pages of documents that directly contradict years of denials about the extent of Trump's relationship with Jeffrey Epstein. We have phone records from telecommunications companies showing 73 calls. We have flight logs from a pilot testifying under oath showing 7 trips. We have deposition testimony from multiple witnesses describing dozens of meetings. This is no longer about allegations or rumors. It's about whether documentary evidence from neutral sources matters when it contradicts a politically powerful figure's version of events. When federal judges order transparency, when phone companies produce records, when pilots testify under oath, and when multiple witnesses provide corroborating accounts, we've entered genuinely unprecedented territory. If there are no political or legal consequences for maintaining a narrative that is disconnected from the documentary record, it establishes that evidence is theater and facts are suggestions. Keep a close eye on this story because it's developing rapidly. More media outlets are combing through the 370 pages looking for additional revelations. Legal experts are analyzing whether the documents create exposure under existing federal statutes. Congressional committees are demanding briefings about what the Justice Department and FBI knew and when. State attorneys general in New York and Florida are facing pressure to open investigations. And voters are watching closely to see whether evidence matters or whether political tribalism has become so intense that documentary proof can be dismissed if it implicates the right person. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. 73 documented phone calls between Trump and Epstein over 2 years. 7 documented flights on Epstein's plane with passenger manifests signed by Trump. 22 witnessed meetings at Mar-a-Lago, according to employee testimony. All of this directly contradicting years of claims that Trump barely knew Epstein. Meanwhile, Trump's legal team is reportedly preparing to challenge the unsealing itself. Congressional Democrats are preparing subpoenas for additional documents, and Republican officials are privately expressing alarm that this issue will dominate the campaign and force them to defend increasingly untenable positions. This isn't just another news cycle that will fade away by next week. This is a documentary record that directly contradicts a central narrative maintained for years by a figure seeking the presidency again. What happens next could determine whether evidence and facts still have meaning in American political discourse, or whether we've reached a point where documented proof can be dismissed if it's politically inconvenient. The evidence is public record now, entered into federal court files and available for anyone to review. The phone records exist in telecommunications company archives. The flight logs exist with passenger signatures that experts have examined. The witness depositions exist as sworn testimony subject to perjury charges. Now we wait to see if accountability and truth still hold any weight in American politics. When documentary evidence directly contradicts years of denials, the stakes have never been higher for the integrity of our political discourse. The evidence has never been more concrete and specific, and the gap between the documentary record and the official narrative has never been more undeniable. Pause for a second and hit that like button if you're finding value in this coverage.